In 1923, it was that for the first time, the leader of an indigenous people demand the recognition by the legal nations of his title as a leader of a sovereign nation, request that was not heard at the time. Even with several demands, the issue of indigenous people rights was not introduced into international agenda until the 1970s, because before this date, the rights of indigenous community were guaranteed by the application of rules of human rights and minority rights, which do not take into account the specificities of this population. One of the characteristics of indigenous people is the place and central role that their territories have in their culture and even in their existence. In this sense, the very definition of indigenous people take into account the community links with its ancestral lands. This is underlined by José Martínez Cobo, Special Rapporteur of the Subcommission on Prevention of Discrimination and Protection of Minority, who, in his studies, tries to identify common characteristics of indigenous peoples. He wrote, "Indigenous community, peoples, and nations are those which, having a historical continuity with pre-invasion and pre-colonial societies that develop on their territories, consider themselves distinct from other sectors of society now prevailing in those territories or parts of them. They form at present non-dominant sectors of society and are determined to preserve, develop, and transmit to future generations their ancestral territories and their ethnic identity as the basis of their continued existence as people in accordance with their own cultural patterns, social institutions, and legal systems." This particular characteristic of their culture is the reason why a specific right for indigenous people is necessary. It is in the sense that the Inter-American Commission on Human Rights, as early as 1985, in the case Índios Yanomami versus Brazil, oriented the interpretation of Article 27 of the International Covenant on Civil and Political Rights on the right of cultural right, affirming that a special right is applicable to these populations. According to the Commission, international law is its present state and as found as clearly expressed in Article 7 of the ICCPR, recognize the right of ethnic groups to special protection on their use of their own language, for the practice of their own religion, and in general for all those characteristics necessary for the preservation of their cultural identity. Thus, even before the adoption of specific rules for the protection of indigenous people's rights, the interpretation of human rights obligations and minority rights was adapted to the specific of each people, at least at the Inter-American System on Protection of Human Rights. The adoption of an instrument specific to the rights of indigenous people did not appear until 1989, with the International Labour Organization Convention number 1669. Unfortunately, the provision of these conventions are rather weak. It certainly requires the states to take into account, recognize, protect, and adopt the necessary measures to establish protection of the social, cultural, religious, and spiritual values and practice of indigenous peoples, but in a very vague manner. The case law of the regional court have been more innovative. One example is the Magaña Sumo Ayastini community versus Nicaragua, in which the Inter-American Court of Human Rights recognized the importance of the link between the territory and the existence of indigenous people. According to the court, given the characteristics of the instant case, some specifications are required on the concept of property in indigenous community. Among indigenous people, there is a communitarian tradition regarding a common form of collective property of the land, in the sense that ownership of the land is not central on individual, but rather on the group and its community. Indigenous group, by the fact of their own very existence, have the right to live freely in their own territory. The close ties of indigenous people with the land must be recognized and understood as fundamental basis of their culture, their spiritual life, their integrity, and their economical survival. For the indigenous community, relations to the land are not merely a matter of fact of possession and production, but a material and spiritual element which they must fully enjoy, even to preserve their cultural legacy and transmit it to future generations. But it was only in 2007 that a more specific and comprehensive instrument will be adopted, the United Nations Declaration on the Rights of Indigenous People. It protects, among other things, the cultural rights of indigenous people by prohibiting the forced assimilation and the destruction of their culture, as well as provision on the return of cultural property. Although the declaration is not binding, it has a strong influence on the recognition of rights of indigenous people. Moreover, a regional declaration followed the UN declaration, namely the American Declaration on Rights of Indigenous People, adopted in 2013. In the latter, collective rights are more strongly stated, and maybe because of the influence of the inter-American system on human rights. The declaration stated that indigenous people have collective rights that are indispensable for their existence, well-being, and integral development as people. In that regard, it states recognize and respect the rights of indigenous people to their collective action, to their judicial, social, political, and economical systems or institutions, to their own culture, to profess and practice their spiritual beliefs, to use their own tongues and language, to their lands, territory, and resources. States shall promote, with the full and effective participation of indigenous people, the harmonious coexistence of the rights and systems of different populations and groups and cultures. We can see here that the link between the existence of indigenous people and their land and the environment preserving this land is very important for the continuity of their cultural existence. However, the concept of indigenous people is more developed, the rights of indigenous people is more developed in the inter-American systems. For instance, in Africa, there is not much recognition of indigenous people. They rather specific says the rights of people or tribal. However, the African Court of Human Rights and People Rights states the need to preserve the culture of people and identity and equal enjoyment of the common heritage of mankind. And that is the minorities and the society as a whole. Finally, in the European territory, you cannot find a lot of indigenous people. Maybe the Sami people in the Arctic Circle is the most prominent example of indigenous people. However, the European Parliament has adopted in 2018 a resolution on the violation of the right of indigenous people in the world, including the issue of land grabbing. The Parliament recognized the link between violations of cultural rights of indigenous people and this dispossession of their ancestral lands. According to the resolution, whereas human rights treaty recognize the right of indigenous peoples to their ancestral land and resources, and provide that states must consult indigenous people in good faith in order to obtain their free, prior, and informed consent pertaining to projects that can have an impact on their traditional way of life that may threaten the natural resource they have traditionally cultivated and continue to depend upon, or that can lead to the displacement of their population and to a consequent loss of their distinct cultural heritage, both tangible and intangible. The adoption of these multiple documents, binding or not binding, demonstrate that states recognize the importance of preserving culture of indigenous people, and that although their culture manifests differently depending on the population, state also recognize it is often linked to the ancestral territory and is vital to preserve its integrity. In this sense, different types of interference on their territory, especially regarding environmental degradation, can cause significant cultural harm that must be repaired. One of the core principles of international law is the obligation of states to repair their wrongful acts. In the 1928 judgment of the case concerning the factor Edgeworth, the Permanent Court of International Justice already states that it is a principle of international law and even a general conception of law that any branch to an engagement involves an obligation to make reparation. The essential principle contained in the actual notion of an illegal act, a principle which seemed to be established by international practice, and in particular by the decision of arbitrary tribunals, is that reparation must, as far as possible, wipe out all the consequence of the illegal act and establish the situation which would, in all probability, have exist if the act has not been committed. In the sense, why I'm trying to say with this quote, that when we are applying a reparation for environmental damage, the cultural aspect that had been harmed and lost and harm and this injuries suffered by indigenous people must also be included in this reparation order. However, to deal with reparation of degradation of cultural heritage of indigenous people, it is to deal with their own existence. In the 2000s, a study carried out among Canadian indigenous people enabled its members to express their particular vision of the notion of cultural heritage. In her testimony, Andrea Sanborn states that cultural property, to me, is anything about us, for us, given to us by our Creator, and is to be used by all of us with respect. And in the sense, she stated, okay, my whole existence as Andrea is a cultural property. It's who I am. It's all the tradition of the, I'm sorry, I cannot pronounce correctly the name of the indigenous people that belong to me and belong to our people. It's the language, the Kalawa language, and most important, of our values we have as people, Mayashala, which means respect or treating someone good or something good. It's protecting all of our songs, dances, and histories. It's protecting our land because all of the land basis comes out of our creation stories. That's cultural property. So are the things. It's family passing on family values and the history of each family and all the treasures they own culturally. A tentative definition of cultural harm is fundamental to understand how can we repair this type of damage. The definition on environmental damage varies considerably. It can be defined, as is defined by Philip Sands, as a damage to natural resource alone, or damage to natural resource and property, which forms part of cultural heritage, and it can also include damage to landscape. In the sense, environmental damage may range from harm to biodiversity to the impairment of traditional lifestyle of indigenous people. According to Doro Geia, environmental damage has an anthropological view, an injury to humans and their property through the natural environment in which they live, and an ecocentric one, the harm direct to environmental with itself. However, when we apply the ecocentric definition of harm to the environment, we are losing some central aspects of the injuries suffered by indigenous peoples, which are mostly vulnerable when are the relations and the recognition of their ancestral lands. The jurisprudence of international tribunals also takes into consideration the cultural harm. we can see an evolution of the assessment of what is cultural environmental damage from the Trials Melter case of 1939 and 1941 to the 2000 award of the people of Inuiatak from the Marshall Island Nuclear Claims Tribunal. In the Trials Melter case, the United States argued that the fumes from a Canadian company caused damage to American agriculture, livestock, property, and business. To assess this damage, the arbitral tribunal analyzed the loss in value of the land. Therefore, it used purely an economical approach and did not take into consideration other harms and injuries that could be generated by the illegal wrongful act. A contrário, the award concerned the damage to the land of the people of Inuit. It stressed the irreversible aspect of the environmental damage. This case concerned damage to the land resulting from or arising out the nuclear testing programs conducted by the United States between 1949 and 1958 on the lands of the Inuit people. In the words of the arbitral tribunal, while the tribunal is charged with the determination of this damage, the claimant has suffered damage beyond that which money can compensate. The destruction and disruption of their community and the attendant's lifestyle and values cannot be compensated with an award of dollars. The passage of time and changes in the culture preclude a return to the way things were half a century ago. While that which was lost may be priceless, it does not mean it was without value, nor it justify an award which is not firmly based in fairness and reasonableness. In this sense, although the reparation was made in pecuniary form, it corresponds to material and moral and abstract damage as past and future loss of the use of the land, restoration of a safe and productive state, and the hardships suffered by the people of Inuiatak as a result of their relocation. This approach is not limited to the economical value of the injury. Other aspects of the damage were also taken into account. For example, the impact of life of those that use the environment for their cultural practice. Thus, a broader definition of environmental damage seems to be the most adequate one, and it has to be applied by tribunal and legal literature. This definition must include damage to environment itself, as well as for the individual that depends on this environment. After all, damage to environment can result in moral and spiritual harm, especially to indigenous community and other groups that rely their culture on the environment. The exclusion of this impact in the establishment of the reparation will mean that an important consequence of the international wrongful act in question would be negligent. Thank you for your attention.